But it's not, you say discretionary, but let me put back around with that. I mean, you agree that there are criteria.
I don't know. Sorry, John.
There are criteria in the statute.
I don't deny the fact that there's criteria. However, what I would like to call your Honor's attention to is what opposing counsel failed to call your attention to. The fact that there are 9 pieces of broad criteria, practically a laundry list of these pieces of criteria in essence, that are discretionary by nature. I won't deny that some are objective, just the first one, which they chose to mention due to its objective nature, age, maturity. However, as your Honor goes down the list, it's far more than that. Intelligence is meant to be gauged by an ordinary citizen, a non-government employee. They're meant to gauge affiliation with potentially threatening character. And perhaps most concerningly, they're supposed to serve as a judge of general trait of character as a state law-abiding person. If that's not subjunctive, Your Honor, I don't know what is. It's discretionary by nature in saying that they are meant to make a decision as a non-government individual, ordinary citizen, simply operating a gun retailer, as to who is, I quote, who possesses general trait of character as a state law-abiding individual. It's subjunctive by nature. Does that adequately answer your Honor's question?
It does. But let me ask you this way. Is it your contention that Cantrell was or was not unfit?
Under the circumstances as they existed in May of last year, Your Honor, it's going to be our contention through the testimony of Ms. Cantrell, excuse me, and the other witnesses we called today that she was in fact fit. Yes, Your Honor. And so we believe that that's the matter in hand for the jury today through a court proceeding, not for a simple individual, again, acting as a quasi-judiciary figure as prescribed by the statute to make that judgment. With that, I would also like to call the court's attention to our second factor we'd like to bring up, and being that it does not hold consistency with historical standards as is required in the United States Bureau. We can't dispute the fact that as is ruled under Bureau, restrictions may be permitted if historical precedent allows. However, as the Bureau ruling, as Justice Thomas stated explicitly in the Bureau ruling, such restrictions may only occur if carrying handguns for self-defense, so long as these states employ objective licensing requirements. Emphasis on the term objective. As we just established, Your Honor, these are discretionary measures. They're not effective by nature. Some may be, however, others are not. And the fact that the individual has to act on it, as I quote, totality of the circumstance, as prescribed in the statute, clearly gives them undue power, not prescribed to them in spirit. And opposing counsel has not made any analogous reference to any analogous law throughout American history to say that such precedent has been set or such historical tradition exists.
No, let's just think it's practical. Not in terms of the law, in terms of the thought experiment, what this country was like 150 years. And you've all seen Western films, not the movies of real life. But I think it is fair to say that firearm possession and usage was in the Old West, was fairly common. You agree with that?
Absolutely, Your Honor.
But at the same time, would you not agree that even in that environment, that the citizens of a community had an interest in regulating that perhaps the town drunk didn't have a loaded gun and waved around with fire? You would agree that even then there was a recognition that some limitations have to be placed on some people, whether it be drunk or a person mentally ill or what have you.
Absolutely. I think there's always been grounds for or some understanding that there must be restriction. However, I feel upon looking at most recent court rulings as issued by the Supreme Court of the United States, most particularly the ones I've been referencing being Heller and especially Buren, that the most recent Supreme Court rulings are meant to modify and also restrict the nature of those restrictions that can take place. And while we believe there is, of course, need for restriction, it has been regulated through Supreme Court regulation, or excuse me, through former Supreme Court decisions and rulings on such cases that there are grounds under which we can place these requirements and ways in which we can define the scope of how these regulations can be placed. And we're just looking at the Buren requirement alone, stated once more, objective licensing requirements, again, with emphasis to the word objective, that has been regulated by the court in describing the nature of how and in what manner we could apply this regulation. that adequately answer your question? So with that, we would just like to call attention to, without the existence of any analogous historical tradition that opposing counsel has failed to bring up, resorting to only rhetorical flourishes, the law is in direct violation of the Second Amendment to the United States Constitution, as it not only inhibits upon the individual's right to keep and bear arms by restricting its buying and therefore selling, but it also holds no historical tradition as was prescribed necessary in Europe. Thank you for your time, Honor. Your Honor.
Rebuttal, Your Honor? Absolutely. And what on the last point that
Yes,
what is the historical precedent that is most closely related to this?
yes, Your Honor. In contrast to what Mr. Stevenson just said, I did bring forth historical analysis. Throughout the analysis of Heller and Bruin, in which they took upon the historical tradition of America, it was found throughout multiple cases, such as colonial era Connecticut, as well as Massachusetts, that there was a direct restriction on the usage of firearms by felons and mentally ill. Now, in furtherance of this understanding, Connecticut and colonial Massachusetts directly stated within their state constitution that all affrayers, disturbers, and those that may broach the peace and the safety of the public shall not have the right to bear arms.
But who made those decisions?
These were affirmed within the constitutions of the states and later found to be constitutional under New York Rifle and Pistol Association versus Bruin by the Supreme Court.
Right, but I'm saying who, as a practical matter, who or what personal entity enforced it?
I believe this would have been enforced by the sheriff in colonial times, Your Honor.
So law enforcement.
Yes, Your Honor. However, in specific regard to the understanding that Mr. Stevenson is claiming that the seller is being put in a quasi-judicial position, that is simply untrue. Now, to call upon the actual statements in the act itself, of which you may acknowledge, it asks for very objective values. It may be argued that character is very subjective. However, in the case of this act itself, it is not. We point to that of the Chalice regime of the modern day example of this act, which does state that they may look for a character of general trait of temperament drawn from the prior actions of this act, such as, does this person have a criminal record? Yes or no? Does this person have a history of mental illness? Yes or no? Is this person of age to even buy a gun? Yes or no? These are very clear objective values of which they draw upon to understand whether this person has a character of temperament. Now, given that this is an as-applied challenge, we do not need to look upon the other statements of intelligence or character, which do have a historical background, but rather we look specifically to the very grounded and objective values of Drew Cantrell. Did have a criminal history. Drew Cantrell did not have professional training in firearms, and thus Shooting Star Gun Club failed to consider whether Drew Cantrell had proper character of temperament. Now, in this as-applied challenge directly, it also counsel said that we failed to acknowledge the actual sale of firearms to Justice Carbo. However, in our claims itself, in the very beginning of this case, it says either the sale of the firearm to Justice Carbo or the reckless entrustment of Drew Cantrell. We as a plaintiff choose to acknowledge that Shooting Star Gun Club has failed in their duties with the reckless entrustment of a gun to Drew Cantrell, and this act means not to restrict Drew Cantrell or Shooting Star Gun Club from the right to keep and bear arms, but only to ensure that Shooting Star Gun Club is held liable for entrusting a gun to a person that is not a safe, law-abiding citizen.
Your time is cut out. One more question. As a practical matter, if I were to scheme to basically deny the motion and say that you cannot proceed under the statute, practical matter, what does that do to the presentation of the jury?
To the presentation of the jury and trial, Your Honor, 3 exhibits are to be excluded from evidence, that of which suggests that Shooting Star Gun Club did not properly evaluate Drew Cantrell, as well as one of the charges being dropped, that of Shooting Star Gun Club being held liable for the reckless entrustment of a gun to Drew Cantrell.
Does it affect the remedy of the damage?
Yes, Your Honor. It affects it in such that the charges against Shooting Star Gun Club would be less volatile, and it would not be to the proper extent of ensuring that Shooting Star Gun Club is found not liable for the hiring of Drew Cantrell, but also the action of retaining Drew Cantrell and later entrusting them with a deadly weapon. Thank you, Your Honor.
Yes, sir. Appreciate arguments by both of you. Just a couple of minutes. I think you both argument based on the argument and briefing with counsel. I'm going to section 7 as applied in this case is unconstitutional. Do they use conduct protected by the Texas Secretary? Not satisfied that the particular mechanism that the statute chooses to manner in which we decide who's in fit, including that such as in this case. It's a close call. Constitutional and don't believe that as practical affect points in the case. Right, and so because I denied the motion, second cause of action is dismissed with prejudice. Excluded from evidence. That concludes the oral argument, and counsel is ready to proceed. Housekeeping matters. So first, I'd like to ask, starting with plaintiff and defense, to make your question.
Yes, Your Honor. Good afternoon. My name is Haley Ray Newport, and I, along with my co-counsel, will be representing the plaintiff, Justice Carbo, in today's case. May my co-counsel introduce themselves?
Jack Johnston for the plaintiff.
Alexander Tent for the plaintiff.
Holly Pierce for the plaintiff.
As well as our witnesses.
John Canoni portraying Justice Carbo.
Olivia Cavoto portraying Ross Hernandez. Linro Leo portraying Dr. Morgan Judd.
Your Honor, just to clarify, would you like us to handle preliminary matters now or after opposing counsel introduces?
Let's let the defense make their introductions, and then I'll come back.
Yes, Your Honor.
Good evening, Your Honor. My name is Grace Kowalski, and I'm joined by my co-counsel.
Good evening, Your Honor. My name is Paul Stevenson, and I'm joined by co-counsel.
Good evening, Your Honor. My name is Christian.
And now for our witnesses.
Good evening, Your Honor. My name is Fabiana Rodriguez, and I will be portraying Drew Cantrell.
Good evening, Your Honor. My name is Hugh Riggins, and I'll be portraying Captain Jackson.
Good afternoon, Your Honor. My name is Nicholas Galea, and I will be portraying Avery Flynn.
And tonight, we are going to represent Shooting Star LLC Gun Club.
Yes, Your Honor. The plaintiff would like to invoke Rule 615, request that all witnesses remain constructively sequestered, with the exception of party opponents.
Done.
We would also like to ask permission to move around the courtroom freely. Does this extend to the witness as well as the bench?
Yes, no need to ask the permission of the judge.
Yes, Your Honor. And with that, the plaintiff is ready to proceed.
Now, I would just make a comment. Because this room is considerably wider than a typical courtroom, that we all be mindful of the fact that perhaps this is more of the realm than this over here. I'll say on that.
Yes, Your Honor. We'd just like to ask you for preferences for sustained objection. Would you like us to ask for it to be stricken or noted as such?
Ask.
And that's all for us.
That then,
Yes, Your Honor. Your Honor, opposing counsel, and members of the jury. Shooting Star saw the signs, but they ran the risk. I'd like to begin today by introducing you to my client, Justice Carbo. This last May, Mr. Carbo decided to buy a gun from Shooting Star Gun Club. He wanted to feel safe in his crime-ridden city. As a first-time gun owner, he took a safety course at Shooting Star, instructed by Drew Cantrell. But within minutes of taking this class, Mr. Carbo found himself on the floor, bloodied, screaming in pain. His instructor, Ms. Drew Cantrell, had shot him in the leg. How could this have possibly occurred? Well, as it turns out, Shooting Star saw the signs that Ms. Drew Cantrell was incompetent, but they ran the risk and allowed her to teach a safety course. I'd like to take you back to the beginning of Ms. Cantrell's career. Back in June of 2020, Shooting Star and its owner, Skylar Coleman, initially hired Ms. Cantrell as a sales clerk. Her job was simple: managing the cash register and handling inventory. It was uneventful up until May of 2021, when Ms. Cantrell got into an argument with a coworker. In the heat of the moment, she took out a gun and pointed it at the other person, the barrel at their chest. Not only did Shooting Star fail to fire Ms. Cantrell in that moment, but just 3 months later, Ms. Cantrell was promoted to firearm safety instructor. But even as a newly minted instructor, Ms. Cantrell continued to violate the very safety protocol that she was now supposed to teach. In November of 2021, Ms. Cantrell walked out of the gun range and into the shop with the general public with her gun still loaded. Today we're going to show you that Skylar Coleman saw the signs, but she ran the risk on May 28th by allowing Drew Cantrell to teach a safety course. You see, while Ms. Cantrell was instructing Justice Carbo, she placed him to her right and raised her arm to demonstrate how to fire a gun. The two bumped into each other as a result of careless proximity. Justice Carbo was shot in the leg. Today, we're going to show you that this tragic incident occurred because Shooting Star saw the signs, but they ran risk. Members of the jury, we hold the burden of proof in today's case. We will prove by preponderance of the evidence that Shooting Star negligently hired and retained Drew Cantrell as an employee. In order to do that, we're going to show you 2 things. First, we're going to show you that Drew Cantrell was unfit to be a firearm safety instructor, and Shooting Star had known or should have known this fact. Second, we're going to show you that Justice Carbo's injury was foreseeable. It was a direct and proximate cause of Drew Cantrell's carelessness. We'll prove each of these things to you by preponderance of the evidence, meaning that today, if the evidence tips the scale even slightly in Justice Carbo's favor, then you must hold Shooting Star liable for his injuries. In order to meet this burden, we're going to show you that Shooting Star saw the signs. Sign number 1. Ross Hernandez, a local who frequented the bar within the club, will tell you how she watched in horror as Drew Cantrell pointed a gun at another person. In addition, you'll hear how Skylar Coleman, the owner of the business, failed to fire her. In fact, she was simply given a token reprimand, a talking to, and some words to be filed away on a paper, never to be seen again. Sign number 2. Drew Cantrell didn't have the experience necessary to become a firearm safety instructor. Now, the plaintiff is going to tell you that Ms. Cantrell had 2 firearm safety certificates. But today, we're going to call Dr. Morgan Judd to the stand, an expert in firearm safety. She'll explain that these 2 certificates didn't change the fact that Skylar Coleman gave Drew Cantrell no training in firearm handling for promoting them to become an instructor. And finally, sign number 3. Ross Hernandez will also tell you how in November of 2021, Drew Cantrell violated safety protocol again by failing to unload their gun within the shop. We'll show you how Skylar Coleman saw each of these 3 signs. And finally, we'll show you that she ran the risk. Dr. Judd will explain that given these 2 instances, Ms. Cantrell's lack of experience, they didn't meet the threshold members of the jury to be a firearm safety instructor. Yet, throughout today's trial, you'll hear that Shooting Star let them teach a course anyways. You'll hear how Justice Carbo paid the price for this decision. Members of the jury, throughout today's trial, ask yourselves, how could this have happened? Would this have been prevented? The plaintiff? We're going to show you that Shooting Star saw the signs, but they chose to run the risk. Which is why at the end of this trial, my co-counsel, Ms. Pierce, will stand right here and ask you to hold Shooting Star liable.
Yeah, I proceed. It was an unfortunate accident, but it was just that, an accident. May it please the court, Your Honor, opposing counsel, members of the jury. Now, plaintiff came before you and told a story as to what happened on May 28th, 2022. But that was only their version of the story. Now let me paint the full picture. Justice Carbo, a novice gun owner and resident of Imperial, reached out 2 months prior to Shooting Star's owner, Ms. Skylar Coleman, inquiring about purchasing a gun. After emailing back and forth, Ms. Coleman offered to personally meet with Justice Carbo, not once, but twice, which plaintiff has failed to mention. During these meetings, Ms. Coleman went over how Mr. Carbo would be able to safely purchase a weapon, and she even offered him a free firearm safety course. Now, on the day in question, Ms. Cantrell Mr. Carbo's firearm safety instructor, provided Mr. Carbo with all the safety precautions he would need to know to maintain his safety. He gave him safety equipment, and he instructed him to stand at a certain but safe distance to his right. Now, as Miss Cantrell was demonstrating how to fire that weapon, Mr. Carbo failed to maintain the instructed distance. And as Miss Cantrell fired that weapon, the recoil forced her arm backwards and to the right, and Mr. Carbo jumped and forcefully struck Miss Cantrell's arm, causing the weapon to fire a second time. We, the defense, here today, bear no burden. However, plaintiff must prove, by preponderance of the evidence, that Shooting Star was negligent in the hiring, supervision, or retention of Drew Cantrell. Now, we, the defense, will prove Storm Chase, Shooting Star, not liable for 3 reasons: diligence, distance, and a defective weapon. First, diligence. Mr. Cantrell was perfectly fit and qualified to handle that weapon on the day in question. Miss Cantrell, who holds a firearm safety certificate, instructed Mr. Carbo to stand at a certain distance to her right, and went over all the basic firearm safety rules that he would need to know. Now, as Miss Cantrell was demonstrating how to fire that weapon, Mr. Carbo leaned in to get a better look, directly against Miss Cantrell's instruction. And as Miss Cantrell fired that weapon, the recoil knocked her arm backwards, and Mr. Carbo knocked into her. Now, second, distance. Avery Nguyen will come before you and tell you how Shooting Star has worked tirelessly to ensure a safe and collaborative community. As an avid gun enthusiast and daily visitor of Shooting Star, he will testify to how that company has actively worked to be the safest it could possibly be. Now, and he will tell you how on the day in question, Mr. Carbo failed to maintain the instructed distance that Miss Cantrell advised him to stand. Third, a defective weapon. Captain Jacqueline Saab will come before you and explain how he did the one thing plaintiff failed to do: inspect the gun properly, that same gun that was fired on the day in question. Now, he will explain how the gun was defective for 2 reasons. First, over violent recoil. And second, an atypically sensitive trigger. He will explain how Miss Cantrell was perfectly qualified to handle that weapon, and how nothing could have prepared her for that recoil on that weapon. And he will explain how if the weapon, that Glock 22, acted as it should have, we wouldn't be in this courtroom here today. And for those 3 reasons, diligence, distance, and a defective weapon, we the defense ask that you keep those 3 factors in mind throughout today's trial. And at the end of today's trial, my co-counsel, Grace Kowalski, will come before you and ask that you find Shooting Star LLC not liable. Thank you.
Your Honor, at this time, the plaintiff calls Justice Carbo to the stand. Good afternoon.
Howdy.
Could you introduce yourself to the jury?
Of course I can. My name is Justice Carbo, C-A-R-B-O.
Mr. Carbo, why are you here today in court?
I'm here in court today because Drew Cantrell, an employee of Shooting Star, shot me.
Mr. Carbo, I'd like to take things back just a little bit. Why did you originally want to go to Shooting Star?
I originally went to Shooting Star because I didn't feel safe in Empyrean anymore. I had my car broken into several times and I even got robbed walking home at night one time.
And just to clarify, what was Shooting Star?
Shooting Star is a gun club and I really wanted to go because it was just a one-stop shop where I could get all of my gun purchasing needs. Where I could both get trained in how to use a gun safely and purchase it.
Once you decided that you wanted to purchase a gun, how did you end up deciding on Shooting Star?
Well, I first heard about Shooting Star through word of mouth, and then I also heard the commercial, and that jingle just really sticks with you.
Did you end up reaching out to Shooting Star?
Yes, I did. I started off by emailing Skylar Coleman, the owner.
What did you and Skylar Coleman discuss?
Well, I first started off by introducing myself and just saying that I'm completely new to guns. However, I'm interested in letting purchasing for self-defense. Then we kind of went back and forth a little bit about some semantic stuff, but in the end, Miss Coleman, excuse me. Ms. Coleman asked me to come on down to the shop and we would talk then.
Mr. Carbo, what happened when you eventually came down to the shop?
Yeah, I started talking with Ms. Coleman and she spent over an hour with me just discussing ways that I could store it, handle it, and just purchase a new firearm.
Did you do anything else while you were at Shooting Star that day?
Yeah, I decided that I was going to purchase a firearm and filled out some government forms.
Mr. Carbo, did you ask for anything additional while you were there?
Yes, I did. I made sure to ask for a gun safety training course so I know when learn how to use a gun and use it safely.
When did you decide would be a good time to take that course?
Ms. Coleman and I decided for 2 weeks later that I would come back and we would do everything else then.
Mr. Carbo, what happened 2 weeks later when you came back to Shooting Star?
Well, I went back 2 weeks later, like we agreed upon, and when I walked in, Ms. Coleman greeted me as Empyrean's newest gun owner. And so I had to refill out those same government forms I filled out 2 weeks prior, as well as they did a background check on me.
Now, did you end up getting the safety course that day?
Well, before I got the safety course, Ms. Coleman, after I finished my background check, started to reach under the cabinet and pull out the firearm I just purchased. And I had to remind Ms. Coleman about the safety training course, to which she responded, "Oh, yeah," and then asked for one of their employees, Drew Cantrell, to come up from the back.
What happened once Drew Cantrell came up from the back?
After Drew Cantrell came out from the back, Ms. Coleman had to remind her about the safety training course, which she responded, "Oh, yeah, right," and then took my gun and me into the shooting range.
What happened after Drew Cantrell took you and the gun into the shooting range?
Well, we walked all the way to stall 11 where the safety training course would be taking place, and she introduced me to the other person taking the course, Nick Hawkins.
Your Honor, at this time, I'm going to show the witness what has been marked as Plaintiff's Exhibit 2G for identification. Let the record reflect that my co-counsel is now screen sharing that exhibit. Could you please let me know if you see that on the screen? Members of the jury, can you see the exhibit? Mr. Carbo, can you see it?
Yes, I can.
Mr. Carbo, could you please identify Exhibit 2G for the court?
This is a photo of stall 11 and 12 with some X's marking where myself, Drew Cantrell, and Nick Hawkins were standing.
And does the location of these 3 X's, as well as the picture itself, appear to be accurate?
Yes, it does.
Your Honor, at this time, the plaintiff would like to offer Exhibit 2G into evidence.
No, Your Honor.
Mr. Carbo, for the sake of the jury, Could you please explain a little bit more about the location of these X's and which people they represent?
Yeah, of course I can. So the blue X on the left, that's Drew Cantrell, and obviously he's one leading the course, so he was taking in Saul 11 since he would be shooting down it. Then he instructed me to stand to his right, so I am represented by the red X next to him. And then Drew Cantrell instructed me forward to stand to my right, that's why they're represented by the yellow X on the left.
You mentioned that Drew Cantrell told you to stand in that location. At the time, did you think anything of where you were standing?
No, I was just doing as I was told, and since Drew Cantrell was the one leading the course, I would assume that they were the expert, and so I just listened to what they said.
After you listened to what they said and moved to that position, did Drew Cantrell do or say anything that would indicate you'd made a mistake?
No, Drew Cantrell never told me that I needed to step back or that I was in the wrong position, so I assumed that everything was fine since they didn't say anything.
Co-counsel, thank you for sharing that exhibit. You can take it down now. Mr. Carbone, after you stood in that position, what happened next in terms of the safety course?
Next, Ms. Cantrell gave myself and Nick Allred some ear protection and eye protection.
And after you were provided the protection, did Drew Cantrell move to show you how to actually fire the gun?
Yes, he did. Then we moved on to how to actually shoot and fire a gun.
And once this happened, or at the time that Drew Cantrell went to fire the gun, did you notice anything out of the ordinary?
I mean, Drew Cantrell was doing everything that they explained, such as not shooting or pointing the gun at anybody, only shooting the gun as it was loaded, keep your hand off the trigger unless you intend to shoot, stuff like that. However, one thing I did find kind of weird is that before firing the first shot, Drew Cantrell flinched a little bit. And I mean, I'm no gun expert, however, it seemed kind of weird to me.
Mr. Carbone, what happens after Drew Cantrell flinched right before firing?
Well, Drew Cantrell flinched. Then they fired the first shot, and the next thing I knew, the gun was pointed at my right leg.
Mr. Carbone, what happens after Drew Cantrell pointed that gun down at your right leg?
After the gun was pointed at my right leg, the next thing I knew, my whole leg went numb. I was on the floor screaming in pain, and there was blood everywhere.
Thank you for talking about that, Mr. Carbone. Now, I just have a couple more questions. I'd like to bring your attention back to the lessons that led up to that incident. To the best of your knowledge, do you recall Drew Cantrell mentioning any technical specifics about the Glock 22?
No, I do not.
To the best of your knowledge, do you recall Drew Cantrell mentioning that this gun had a light trigger?
No, I do not.
Thank you, Mr. Carbone. Your Honor, at this time, I have no further questions.
Good evening, Mr. Carbone. Now, I'd like to talk about the events leading up to the incident. You pursued your purchase at Shooting Star because of the great reviews, is this correct?
That was one of the reasons why I chose Shooting Star, yes.
And prior to the safety course you took, you met personally with Ms. Coleman twice.
Yes, I did meet with Ms. Coleman twice.
And during this first meeting, she described safe gun handling.
She described some of the basics of it, however, never actually provided like a fully in-depth safety training course.
Yes, Mr. Carbo, and she explained safe gun storage,
Yes, as well as handling.
and she explained all the paperwork you would need to fill out to legally possess a gun.
Yes, that is correct.
And now, on the second meeting, Mr. Carbo, Ms. Coleman gave you a waiver that you would need to sign prior to entering the safety course.
Yes, it was, prior to the safety course?
Yes.
Yes, she did.
And do you have knowledge of this document?
Yes, I do.
Your Honor, permission to that is the chair. Exhibit 7. Mr. Carbo, is this a fair and accurate copy?
Yes, it is.
Is this your signature?
Yes, at the bottom.
Your Honor, permission to enter exhibit 7 into evidence.
No objections, Your Honor.
Now, Mr. Carbo, I'd like to direct your attention to bullet point 2. Follow along silently as I read aloud. I am fully aware of the risks and hazards connected with being on the premises and participating in the gun range. And one line down. I hereby elect to voluntarily participate in the gun range, to enter upon the above named premises and engage in activities, knowing that conditions may be hazardous or may become hazardous or dangerous to me and my property. I voluntarily assume full responsibility for any risks of loss, property damage, or personal injury, including death that may be sustained by me. Did I read that properly?
You can read, yeah.
So, Mr. Carver, we could agree that to some extent you assume the risk.
I mean, that's why one of the reasons that the form was on.
And you have knowledge of the risk and signing it.
I mean, obviously, I read the form before signing it.
Thank you, Mr. Carver. Now, on the day of the incident, Mr. Cantrell instructed you to stand at a certain distance to his right.
Yes, Miss Cantrell instructed me to stand immediately to her right.
And Ms. Cantrell warned you of new novice gun owners flinching in anticipation to recoil.
Yes, they weren't about novice gun owners, but since they're an expert, I assume that they would be fine with it. They're proven wrong.
Yes,
But
Mr.
yes,
Carbo. And on direct, you testified to coming into Ms. Cantrell, or making contact with Ms. Cantrell.
I did not. I didn't make contact with that after they finished and
But Mr. Carbo, could you know for certain if you flinched?
I mean, obviously, since I'm a novice gun owner, as Ms. Cantrell would explain, I would like to be a little startled by it. However, I didn't like.
But Mr. Carbo, this is a possibility, yes.
It's a possibility. It doesn't mean it happened.
Thank you, Mr. Carbo. Now, I want to take a step back. You now believe nothing good comes from guns.
Yes, I do.
You even started a nonprofit.
Objection, Your as to relevance. What was that, Your Honor?
What are you specifically saying it's not relevant?
Your Honor, opposing counsel is asking questions as to events that occurred after every single event leading up to the relevant events in this case. And since it occurred after, it can't make a fact more or less likely as required for testimony to be relevant.
Your Honor, this line of questioning will establish Mr. Carbo's intent in following through with this suit here today.
Why is that relevant?
It's relevant because this is why he's pursuing his case against Shooting Star. Mr. Carbo, you believe that Shooting Star should be out of business, is this correct?
I mean,
Objection. Your Honor, at this time, I would like to renew my relevance objection on the basis that, again, the testimony that opposing counsel is eliciting occurred after all of the events. Again, Your Honor, this is a case of negligent hiring.
Your Honor, again, this line of questioning is going to establish Mr. Carbo's intent and bias in today's case at testifying against Shooting Star.
Well, it's just clearly. Could you re-ask the question, please?
Mr. Carbo, is it true that you want to shut down Shooting Star?
I mean, I intend to take every last penny from them.
So you intend to shut down Shooting Star? While taking every penny?
Yes, and I believe that if you were in my situation, you got shot innocently, that you would want to do the same. But
So just to clarify again for the jury, you want to take every penny? Thank you, no, that's it for.
Yes, Your Honor. Mr. Carbo, on cross-examination, there was mention of an impact that occurred between you and Drew Cantrell. Could you please elaborate a bit more as to what actually happened there?
Of course I can. So after the first shot was fired, I felt Ms. Cantrell's right arm bumped into my left arm, and then all of a sudden they were pointing the gun at my right leg.
Your Honor, at this time, I have no further questions. If there is no recross, may my witness be excused?
No, Your Honor.
Right.
Yes, Your Honor. Before proceeding, maybe I ask that opposing counsel remove their exhibit from the screen share, please. Thank you.
It is you, Your Honor.
At this time, the plaintiff calls Ross Hernandez to the stand. May I proceed, Your Honor? Good evening, Ms. Hernandez.
Good evening.
Could you please introduce yourself to the jury?
Of course, my name is Ross Hernandez, and I'm from West Pascal, Ontario.
What do you do for a living?
I'm so glad you asked. I own my own handmade jewelry business called Handmade Moments. This right here is actually one of my best sellers. I've sold like 6 of them.
Are you familiar with Shooting Star Gun Club?
Yeah, it's in the same strip mall that Handmade Moments is in.
Have you ever been to Shooting Star?
Yeah, I go there almost 4 times a week just to get driving. It's because they have a bar/cafe restaurant called Sugar Tavern that's attached.
Are you familiar with any of the employees at Shooting Star?
Sarah told me the owner is one of my best friends. And I enjoyed most of the employees there.
What do you mean when you say that you enjoyed most of the employees there?
There is one employee that I do not particularly enjoy, and that would be Drew Cantrell.
Miss Hernandez, why don't you like Drew Cantrell?
Well, I would always see her being careless with guns, and I always try to avoid her. I don't want to be around that kind of negative energy.
Miss Hernandez, about how many times would you personally say that you witnessed Miss Cantrell acting carelessly?
I'd say about 2 times.
I'd like to talk about this 2 times. When was the first time that you noticed Miss Cantrell being careless with a gun?
The first time was in May of 2021. It was an argument.
What makes you say it was an argument?
Well, I was passing through the shop on my way into the bar. I was chatting with a friend. I was about to go meet my blind date, who I actually wish to show up. But that's the point. I hear some racket going on behind me, so I turn around, and it's Drew Cantrell yelling at another employee.
What happened as Miss Cantrell was yelling at this employee?
Well, at first, she had the gun down by her side, and then out of nowhere, she just took it and pointed it directly at the other employee. I mean, I honestly thought that I was going to watch someone get shot right in front of my eyes. It's pretty scary.
Miss Hernandez, what happened after Miss Cantrell pointed this gun?
I really wish that was silent. And then Skylar Coleman, the owner, she saw what was going on and yelled at Drew Cantrell. If she'd ever point a gun at another person in my shop.
I'd like to talk about the other time that you noticed Miss Cantrell acting carelessly. When was this time?
This next time was in November of 2020.
What did you see this time?
This time, I was going to go talk to Skylar about an upcoming vacation. By vacation, I mean Olive Garden. Don't worry, I'll be going to the real Italy soon. Anyway, so I was passing through the shop, but I went to go find Skylar, where she would normally be in the office during the day, and I heard her just yelling at Drew Cantrell.
What did you hear her yelling about?
It was something about how Drew had left the gun loaded and then she brought it into the shop. And I've got to say, that's a red flag. And trust me, I know a thing about people with red flags.
Thank you, Mr. Hernandez. No further questions, Your Honor.
Your Honor. Mr. Hernandez, I'd like to start by talking of your relation to Shooting Star Gun Club. Now, you own a business in close proximity, correct?
Yes, it's called Handmade Moments. Hashtag small business.
And you attend Shooter McTavern's around 4 times a week.
Yes, that sounds about right.
So we can agree that you got pretty well acclimated with Shooting Star, correct?
Yeah, definitely.
And you even got acclimated with the owner, Skylar Coleman.
Yeah, I just consider that she's one of my best friends.
I'd like to talk about your observations of Miss Coleman. You think she has a great mind for business?
Yeah, definitely.
And in fact, Shooting Star has never been busier since her ideas for advertising.
Objection, Your Honor. Relevance.
Under the rule of evidence, the rule of relevance, it has an extremely low bar, so a fact is relevant if it just makes it more or less probable. So Ms. Hernandez is here testifying on against Shooting Star Gun Club. So asking of what she's observed of Ms. Coleman, her behavior, what she thinks of Ms. Coleman's business, is all extremely relevant here today, since she's testifying against the owner of that business.
Your Honor, I'm not objecting to Ms. Hernandez's opinion about Ms. Coleman's business, but rather specifically about the advertisements and the money brought in from those advertisements, as these were created after May 28th and therefore are irrelevant, as they have nothing to do and make no fact of consequence more or less probable to do with negligent hiring.
Your Honor, I'm referring to prior to May 28th, 2022.
Because the board.
So you'll agree with me that Shooting Star has never been busier since her ideas for advertisement.
Yeah, I mean, I think that she has a great mind for business. Seems like Shooting Star is doing really well.
And in your own words, it's doing well.
Yes, it is.
And you also think Skylar Coleman is a kind and helpful person?
Yeah, I do. I mean, she's one of my best friends.
And you even went to her with a personal problem, didn't you?
Yes, I did.
And she helped you out of that personal problem?
Yes, she did.
So, in short, you have no real problem with Skylar Coleman, the owner of the business you are here testifying against.
That's right.
Next, I'd like to talk about Drew Cantrell. But first, I'd like to establish that you don't know much about guns, do you?
No, I don't. I would consider myself to be a gun nut.
You've never owned a gun?
No, I haven't.
You've never shot a gun?
No.
But certainly, you are not here to testify on behalf of gun safety.
So
You are certainly not here to testify on behalf of gun safety.
I'm not sure what you mean by that.
You're not here to testify for gun safety, are you?
No.
Objection, Your Honor. Relevance.
Your Honor, I'll go again. On direct examination, Ms. Hernandez stated that she stopped interacting careless with guns. I'd ask if she has experience in guns to prove his carelessness. I do believe that it's extremely relevant in this case. You are not here testifying for firearm safety.
No, I'm here to testify that I saw Drew Cantrell pointing a gun at another person.
Well, let's talk about that. In May of 2021, that's the incident you're referring to, correct?
Yes.
But we can agree that Coleman shouted at Cantrell for this incident.
Yes, and I mean, she should have. She pointed a gun at another person.
And also Cantrell was also reprimanded in writing for this as well.
Yes,
So we can agree that Miss Coleman did the right thing and took action towards this incident.
I mean, she seemed to handle the situation, I guess, but it seemed like a pretty big deal.
But that's a yes, she did handle the situation.
I guess so.
Now, I'd like to talk about the second incident you testified against, November of 2021, correct?
Yes.
But you did not see that incident, did you?
No, I just heard Skylar Coleman yelling at your control afterwards.
And as for the second incident that brought us here today, you didn't see that either, did you?
The one on May 28th?
Yes.
No, but I heard about it afterwards because I read it in the newspaper and then I heard more about it from some friends.
And nor were you even in the shop that day?
No, I wasn't. I read about it in the newspaper.
Thank you. No further questions, Your Honor.
No redirect, Your Honor. May my witness be excused?
Your Honor, apologies. The plaintiff calls Dr. Morgan judge to the stand.
If you could just give us about 45 seconds.
Yes, Your Honor. The plaintiff calls Dr. Morgan judge to the stand. Good evening, Dr. Judd.
Good evening.
Can you please introduce yourself to the jury?
Of course. My name is Morgan Judd. Most people know me as Dr. Judd, firearms safety expert, although not the type you would find in Cindy Amber's film.
Please tell us about your education.
Of course. So I grew up in a small town in Hunan of China, and I've always wanted a higher education in the United States. That's when I decided to pursue a PhD in public policy from Tulane University, as well as a master's degree in statistics from Auburn University.
Do you have any professional experience dealing with firearms?
I do. I've worked a little under a decade at the United States Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, where I experienced extensive training on how to track criminals who traffic illegal firearms. and I've also testified multiple times in front of state legislatures.
Your Honor, at this time, the plaintiff would like to tender Dr. Morgan Judd as an expert in firearm safety in accordance with stipulation 12.
Madam Moderator, at this time,
You have that right, yes.
wish to enter the room.
Doctor, I just like to talk briefly about your qualifications in regards to today's case. So, as you stated, as you stated in your report, you were retained in January 2023 to conduct a quote comprehensive analysis in today's case, correct?
That's right.
The case involving the accidental discharge of a weapon.
No, it was not accidental.
A case involving the discharge of a weapon.
That's right. When Miss Cantrell shot Mr. Carbo, apologies.
But we can agree this isn't a homicide case. She didn't purposely attempt to shoot him.
No, no one died after this incident.
Okay, so with that understanding, we can agree that as part of that discharge of the weapon, physics and photonics are heavily involved, correct?
Yes, that is what's within a gun.
And you have no background in physics, though.
I do not.
You-
What I've worked on is with guns specifically. I've had experience, knowledge of it when I worked at the ATF.
But you don't have explicit knowledge of photonics or physics as they apply to firearms.
You don't need to know that in order to understand how a firearm works.
You don't need to know basic physical or photonic elements in order to testify in a trial with a discharge at its very core.
You don't. I'm a professor of this. I've been an associate professor in the Center for Gun Violence Prevention at the Imperial State University School of Public Health.
So, doctor, before you actually testify to what exactly happened at the incident with this discharge, I was just going to ask if you could briefly describe the law of conservation and momentum as it applies to firearms today.
Counsel, apologies. I don't think you need to know the law of momentum in order to understand a gun.
You also can't define the WFP theorem or tell me what it stands for in regards to firearms and physics.
Counsel, I can define that law for you, but you don't need to know that for our case today.
Then, just to appease me, Dr. Judge, can you please go ahead and define it?
No, counsel. I was not called to testify under this today. I was called to testify for 4 things. 1, analyze best gun practices. 2, analyze and describe the Imperial's new responsible firearms sales
Doctor,
practices act.
if I could briefly redirect you back to my question, I'm not asking you what you were called to testify, I just simply asked you if you could go ahead and define the WFE, workforce energy theorem, as it applies to the discharge in today's case. If you
Objection,
can.
Your Honor, improper void dear. We're tendering this witness as an expert in firearms safety, not physics.
I can withdraw the question, Your Honor.
Right? I see.
So, doctor, just to be perfectly clear, you are not here to testify, nor can you testify to the physical or photonical components of the discharge that lie at the heart of today's case.
No, sir. I'm not here to testify about that today.
No further questions, Your Honor, at this time.
Dr. Judd, do you have an opinion about Drew Cantrell's qualifications to be a firearm safety instructor?
I do.
What evidence did you rely on to form this opinion?
I looked at the deposition of Skylar Coleman and Justice Carbo, the affidavit of Drew Cantrell, Nick Allred, and Avery Nguyen, including exhibits 1 through 23.
What methodology did you use in your analysis?
I used a comparison of Ms. Cantrell's actions during her career at Shooting Star versus the bare minimum firearm safety standards adopted within my field, as well as Shooting Star Gun Club.
Dr. Judd, what is your opinion about Ms. Cantrell's qualifications?
In my expert opinion, Ms. Cantrell is
Objection, Your Honor, an improper opinion. Required under 801, in order for an expert witness to offer an opinion before the jury, there are certain criteria that must be met, namely, the materials used to conduct that and methodology which opposing counsel has covered. However, we have not heard whether or not these materials are typical to her fields and are normally relied upon by experts in their field, nor have we heard the degree of certainty that she holds these opinions to, and therefore I believe under 801 basis of expert testimony, such opinion is inadmissible until such foundation is laid.
May I be heard, Your Honor?
Apologies. 702, testimony by expert.
Yes, Your Honor, pursuant to Rule 705 on page 11 of the Imperial Evidence Ordinance, a witness can testify to their opinion without first stating the underlying evidence. However, that can be looked into on cross-examination. In addition, to go to the methods on which opposing counsel is objecting to, pursuant to stipulation 12B on page 4 of our case, in the stipulations, this witness's methods are stipulated as reliable.
If I may be heard, Your Honor? I have no contention against the methods that Dr. Judge consulted in today's case. Rather, my contention is that her opinion is inadmissible until we hear further foundation as 702 requires, being whether or not the methods and materials she used in today's case are typical to experts in her field and commonly relied upon. And second, the standards which she holds her conclusions. Both are commonly required by the 702 standard, and until such foundation is laid, I stand by my objection that such opinions are inadmissible. Absolutely, Your Honor.
Dr. Judd, what is your opinion as to Drew Cantrell's qualifications to be a firearm safety instructor?
In my expert opinion, Ms. Cantrell is unqualified. And she took a firearm safety course on May 28th, 2022.
I'd like to talk with you about Ms. Cantrell's promotion to firearm safety instructor. To your knowledge, was there any benefit to Skylar Coleman in promoting Ms. Cantrell rather than, say, hiring an outsider to the company?
There is. In the work of Ms. Coleman, Drew Cantrell.
Objection, Your Honor. Improper opinion, if it may be heard. I believe the opinion is, counsel just asked the witness to speak to any business incentive as to whether or not there was any method or if there was any incentive for the defendant, Skylar Coleman, to retain an outside individual for the position of firearm safety instructor, as opposed to Ms. Cantrell herself. I believe that goes to both business and financial practice, business operation, as opposed to firearm safety as witnesses have tendered.
May I be heard, Your Honor? Your Honor, we don't need to tender this witness as an expert in, as opposing counsel put it, business practices. If I may proffer as to what this witness was about to say, Skylar Coleman stated that promoting Drew Cantrell would be good for the checkbook. Your Honor, that is a rationally based perception pursuant to Rule 701 on page 10 of the Imperial Evidence Ordinance.
So why do you need this witness to say that? What does it have to do with her opinion?
Your Honor, this goes to Skylar Coleman's reasons for hiring and retaining Drew Cantrell, which is relevant under the case law Molina v. Steele, and why that this Skylar Coleman was retaining Drew Cantrell. In addition, opposing counsel is not calling Skylar Coleman to the stand today. However, under special instruction 7 on page 2 of the special instructions, a witness who is familiar with another witness's statement may reference it in their examination, even if that witness is not called.
I have no problem with her listening to statement as she is an expert witness from Ms. Coleman's affidavit or any other affidavit she's reviewed. My contention lies in the fact that the exact question asked whether or not there was motivation, or whether there was any potential motivation for Ms. Coleman to make a business decision she did. I re-raise my objection to the fact that Dr. Judd has not been tendered as an expert in any sort of business practice, rather simply firearm safety. Question directly called for in a business opinion.
May I be heard, Your Honor? Yes, Your Honor. I believe opposing counsel misheard my question. My question was, to your knowledge, Dr. Judd, was there any benefit to Skylar Coleman in promoting Drew Cantrell versus hiring another to fulfill the position? I was asking to this witness's knowledge, and I was asking about benefit, which does not require them to speculate into the mindset of Skylar Coleman, as opposing counsel phrased my initial question, and it's a rationally based perception under Rule 701, as Skylar Coleman stated that they were good for the checkbook.
I understand it's well argued, but I agree that it's crazy knowing this is.
Maybe the testimony be subsequently stricken, question, and then give a response. Yes, sir.
Dr. Judd, what experience, if any, did Drew Cantrell have with firearms?
Now, prior to working at Shooting Star, Miss Cantrell's experience was solely limited to that of hunting. Even after working at Shooting Star, her experience only consists of 2 certificates.
Dr. Judd, could you please explain what those 2 certificates mean?
Of course, these 2 certificates function similarly to a driver's license. Just like a driver's license is not going to stop a high schooler from breaking traffic laws, these 2 certificates will not stop Miss Cantrell from breaking any gun range safety rules either.
Did Skylar Coleman give Drew Cantrell any hands-on training with firearms before promoting them?
She did not.
Does Shooting Star have any rules about how to handle firearms while at the gun range?
We do. We have a list of 5 gun range, 9 gun range safety rules posted right next to their gun range.
Your Honor, at this time, I'm going to screen share what has been marked as Exhibit 8. Dr. Judd, are you able to see the exhibit?
Yes, I am.
Members of the jury? Opposing counsel?
Yes, very well.
Dr. Judd, can you please identify this exhibit?
This looks like a copy of the gun range safety rules that Shooting Star implemented.
How is it that you recognize this exhibit?
I've examined it in the 36 hours I've spent working on this case.
Is this exhibit a fair and accurate representation of those rules that you've reviewed?
As I see them, yes.
Your Honor, at this time, the plaintiff would like to offer Exhibit 8 into evidence.
Not this time, Your Honor.
Dr. Judd, to your knowledge, did Drew Cantrell follow all of these safety rules while employed at Shooting Star?
No, she broke 3 of these rules on 3 separate occasions.
What was the first rule that was broken?
The first rule is only point at it if you want it destroyed. That means you should only point a firearm as something you intend to destroy.
How was this rule violated?
She violated this rule on May of 2021 when she pointed a firearm at another coworker during a heated dispute.
What was the second rule?
The second rule is if it's loaded, keep it on the lines. That means that loaded firearms should always be kept within the gun range and not be taken and used about within the shop.
And how was this rule violated?
The rule violation occurred only 3 months after Drew Cantrell's promotion to a firearms safety instructor. In November of 2021, Ms. Cantrell brought a loaded Glock 22 into the gun shop and placed it right on the sales counter.
Dr. Judd, what's the final rule?
Final rule is be aware of your surroundings and beyond. That means that when you shoot a firearm, you should always be cognizant of what is around you and around the target.
And how is this final rule violated?
The rule violation occurred in May 28th of 2021. Ms. Cantrell instructed Mr. Allred and Mr. Cardinal to stand in close proximity to her. That means in that moment, she was not aware of her surroundings when she shot the Glock 22 for demonstration purposes.
Are there any posted repercussions for breaking one of these safety rules?
There is. If we look at the bottom of the sign, it states that failure to abide by the above rules may result in removal from the facility or denial of any future shooting privileges.
If you could possibly take down the exhibit. Dr. Judd, to your knowledge, what was Skylar Coleman's reaction when Ms. Drew Cantrell broke multiple of these safety rules?
Ms. Coleman didn't even follow Shooting Star's own safety repercussions. She didn't remove Drew Cantrell from the facility, nor did she deny him of any future shooting privileges. What she did was talking to him and writing him up for the company record. Shooting Star saw the signs that they themselves have, and they ran the risk on May 28th, 2022.
No further questions, Your Honor.
Pursuant to Imperial Rules of Procedure, I would ask the opposing counsel to please put their demonstrative back on screen. We need to cross-examine the witness as they have used it on direct.
Yes, Your Honor. Allow us 1 moment to get it up.
And then could I just bring my device podium into the level with me so I can see the demonstrative?
Sure.
Thank you, Your Honor. And then will you be able to cycle through the slides?
Yes.
Thank you. Okay, proceed. Dr. Judge, today you told this jury a lot about what occurred at Shooting Star, but let's talk about what you chose not to tell them. So we can agree that you mentioned 3 safety violations on direct examination that Ms. Cantrell allegedly committed.
Yes, and it's not allegedly, she did commit them.
Well, let's talk about that, Doctor. So we can agree that the first safety violation you mentioned was, if counsel could advance to the next slide, it only pointed if you want it destroyed. Yes?
That's right.
So we can agree that pointing infers an intentional action, correct?
Say so, yes.
If I point at you, it's intentional pointing you, yes?
I cannot speak to whether or not you want to point a gun at me.
I'm not asking about guns, Doctor, just if someone, the word point, if I pointed our lovely timekeepers over here, I'm voluntarily pointing at them, yes?
Yes, you seem like it.
However, you chose not to tell us that Miss Cantrell didn't intentionally point that weapon.
I did not testify to that on direct examination.
Exactly, Doctor. You didn't tell this jury that in Miss Cantrell's statement that you reviewed, she never intended to aim that weapon at another individual.
She never intended to aim that weapon at another individual, but what she intended was to point that gun at
Doctor.
the shop floor.
Exactly, at the shop floor, not at something, or not at another individual, yes?
That's right, but according to the formal reprimand, that is exactly what she did.
Exactly, Doctor. So she never intentionally wanted to destroy another individual as you tried to mischaracterize that role, yes?
Objection, Your Honor. Your Honor, opposing counsel's inquiring into the truthfulness or untruthfulness of this witness. However, they didn't give proper notice of this in the preliminary matters. We'd be more than happy to screen and share their character evidence form that opposing counsel signed.
If I be heard, Your Honor. I believe that sheet only applies to character evidence. I'm not offering any character evidence to this witness, Dr. Judd, to show truthfulness or untruthfulness. I'm merely questioning what she chose and chose not to tell us throughout her direct examination.
Your Honor, may be heard. This goes to directly to untruthfulness of this witness and should have been mentioned to us pursuant to Rule 608, which is listed on the character evidence form. However, opposing counsel did not give us notice of this line of questioning, and therefore it is improper to ask my witness these questions.
This might be heard one last time, Your Honor. The character evidence sheet infers character evidence, meaning evidence that took place before the course of today's trial. I'm questioning this witness on their truthfulness or untruthfulness during their direct examination, which at the time of spinning that form had not yet occurred. So therefore, I'm questioning her on something that had just occurred. There was no potential to put it on the character witness form. So we can agree she pointed that gun at the floor, per your testimony just now, Doctor.
No, Miss Nguyen stated within her statement that she pointed it at another person.
And Ms. Nguyen, you're aware, is about to testify in this courtroom, or Mr. Nguyen, excuse me, is about to testify in this courtroom today, yes? Ms. Nguyen, if you could identify yourself.
I believe that is Mr. Nguyen.
So we'll have the opportunity to hear what he has to say when he testifies, yes, Doctor?
I believe so.
So moving on to your second room. If you can advance to the second side, counsel. If it's loaded, leave it on the line, correct?
That's right.
And we can agree that without contention that Ms. Cantrell did this, yes?
Apologies, can you please repeat your question?
I'm sorry, the incident that you mentioned, in which she took an unloaded weapon out of firing range, she admitted to it, yes?
No, it was not unloaded. It was a loaded Glock 22.
Yes, doctor, however, not one other individual was in the range at that time, or in the shop at all.
I don't believe so.
But you chose not to tell us the fact that it was a vacant shop when that occurred.
I didn't say it, but of course, it is still a violation of the gun range safety rules.
And furthermore, Ms. Cantrell admits in her statement when she reviewed that both of these were honest accidents. Yes?
I'm not sure about honest accidents, but she tried to claim that it was all accidents.
Exactly. She took responsibility for those accidents and promised to never make them again.
She did not take responsibility. According to Shooting Star's own rules, she should be removed from the facility or denied of any.
We'll talk about that in a
future
moment, doctor.
privileges.
But we could agree she acknowledged both incidents occurred. Yes?
That's right.
And furthermore, Mr. Coleman, or Ms. Coleman, excuse me, the owner, took action to reprimand. We could agree on that?
Yes, against Shooting Star's own rules.
Yep, she screamed and gave Cantrell a lecture like she's never heard before.
Exactly, against Shooting Star's own rules.
Yep, the owner of Shooting Star reprimanded Ms. Cantrell for her actions. Yes,
Like she should have.
exactly,
Yes.
like she should have. And furthermore, if council could advance to the bottom slide, with potential consequences. Doctor, can you see that on screen?
Apologies, there's a lag here. Can you wait a moment?
Absolutely, just please let me know when you could see it. Are you able to see the demonstrative, Doctor?
No, I don't see it currently. Are you referring to failure to abide by the above rules?
I am, Doctor.
Okay,
Please follow along silently as I read aloud. Failure to abide by the above rules may result in removal. I read that correctly?
that is right.
Emphasis on the word may. The word may is in fact present.
Yes, it is.
And we could agree as an individual holding a PhD, the word may does not infer absolute. Yes?
That is right.
It's a potential consequence, not an absolute one.
That is right.
One that has to take into account the totality of the circumstance and allow the owner of the establishment to take an informed decision as to whether or not that action may take place.
That is what should have happened, but it is not what actually happened.
Exactly, because it didn't have to happen per what you just read.
No, counsel, by pointing a gun at another person, that is a felony, aggravated assault. She should have been removed from the facility and denied of future shooting privileges.
But we could agree that that says may count, or may, doctor. Yes, that is the word used in their rules which you testified to.
As I've said earlier, yes.
Furthermore, doctor, if counsel could go ahead and take that demonstrative down. I want to talk a little bit about your background with today's case. You feel very strongly about firearms, don't you?
I would say so. It is a very crucial situation in our country right now.
And we can agree that unfortunately you had a little bit of a prior incident with firearms.
Yes.
Your news, apologies, go on.
Yes, 13 years ago, My niece passed away during a Labor's Day party.
I'm very sorry to hear about that, Doctor. But we can agree that it ignited your professional path against gun violence.
I wouldn't say it ignited, it changed the trajectory of my path, but I've continued my path on gun violence way before that.
Exactly. You've devoted the better part of your life to advocating against gun violence, yes?
I wouldn't say the better part of my life, no.
Well, you regularly write opinion editorials for the Washington Post, Empyrean Times, and Guardians, advocating against pro-gun legislation, right?
That's right. I'm very happy for those opportunities provided to me.
Yes, and you regularly testify in support of new reform efforts for gun-based legislation, yes?
That's right, only if they're proper.
And you want to stop gun violence at its root, don't you?
Of course, it is it's probably one of the highest death rates within our country. Of course I want to
Yeah,
stop.
and that root of distribution, and that root of the problem is the point of distribution with retailers like Shooting Star LLC. Yes?
No,
So would you say it's your sworn testimony today that the root of gun violence is not the point of distribution?
it is not the only route, counsel.
But it's a major point of it's a major root. That's where the guns come from.
No, a minor route.
But we could agree it's a root nonetheless.
Yes,
And you're aware that your testimony today for the plaintiff against Shooting Star has the opportunity to inflict severe financial repercussions on them.
of course.
Yeah, to even shut them down.
I don't believe that can happen.
Doctor, the truth is, you want to put Shooting Star out of business.
No,
You're aware in your plaintiff's own statement, they said in this courtroom on the record that they want to take every single penny from Shooting Star LLC. Yes, doctor?
counsel, I believe I was constructively sequestered. I didn't hear anything that happened previously.
Doctor? Did Mr. Carbo not say in his statement he wants to take every penny from Shooting Star he can?
I was constructively
In his
sequestered.
witness statement, doctor, that you reviewed.
Oh, apologies, I was misunderstanding your question. In his deposition, that is right.
So, and your testimony could contribute to shutting them down and taking every penny, can't it?
I don't believe so.
You don't believe that your testimony for the plaintiff could offer some positive effect to the plaintiff's case?
Of course, I'm here to testify for the plaintiff, but I'm not sure if I can take down Shooting Star Gun Club. They're quite a big business.
But that's a potential
to carry
opportunity
on.
for a person like yourself who's advocated against gun legislation for the better part of their life.
Apologies, what is your question?
You've advocated against guns for the majority of your life, doctor, haven't you?
Objection, asked and answered pursuant to Rule 004.
And furthermore, doctor, we can agree that you have no basics in physics and photonics as mentioned on board.
Objection, relevance.
It goes, I don't believe this goes to the admissibility of the question, I think it rather goes to the weight. I think it's incredibly relevant as to her. You, to clarify, have no background in physics or photonics.
I learned a bit in high school, but PhD or a master's degree or a bachelor's degree,
So doctor,
no.
you can't testify to the specific components of that discharge, can you?
No, and I've not testified about that topic.
No further questions, Your Honor.
Your Honor. Dr. Judd, in your analysis of today's case, did you need to utilize physics and photonics to make your conclusion about Drew Cantrell's qualifications?
No, what I needed to use was the bare minimum firearm safety rules adopted in my field. Nowhere in that would I need to use physics.
And Dr. Judd, today we've heard about some political advocacy. Does this affect your testimony in court today at all?
No, as an expert in gun safety, it is my responsibility to maintain objectivity when analyzing a case and testifying in court.
No further questions, Your Honor.
No, Your Honor.
Yes, Your Honor, the plaintiff rests.
In that case. Okay, so 5 minutes. And we'll see you guys. Okay.
Yes, Your Honor, before we take that break, however, can we ask for a time check from our timekeepers? I have 28:34 remaining for plaintiff and 29:59 remaining for defense. Thank you, Your Honor.
All right, we're in recess.
I mean, I think that makes sense considering there was a like whole foot here, and I think the last class was pretty long. I think they should have enough time to finish, but like I do think it was pretty long in terms of like on the rest of Oh, no, I'm like a student at Chicago. Like they made like the entire module team volunteer for like
I'm
2
sorry,
rounds. That's why I've been here since like 9 in the morning. No, it's okay though. Like, so it must be civic hours. Oh, that's fair.
All right, Liz, are we ready to proceed with the case?
The defense is ready.
All right. Please call your first witness.
The defense calls Mr. Pinchot to the stand. Yeah. Good evening. Please introduce yourself to the jury.
I am Kendra.
And can you tell the jury what you do for a living?
I am a firearms safety instructor at Shooting Star Gun Club.
And can you explain how you were first hired at Shooting Star?
Yes, I was first hired as a sales rep.
And how was the original interview at Shooting Star?
It was very thorough. It was about an hour long, and Skylar Coleman asked me lots of questions about my firearms experience, and yeah, basically anything about that.
So just to be clear, you weren't originally hired as a firearm safety instructor.
No, I was not. But in the meantime, I earned my firearms safety certificate.
Would you recognize a copy of this document?
Yes, I would.
Your Honor, permission to digitally share exhibit, what is going to be marked as exhibit 19. Is this a fair and accurate copy?
Yes, it is.
Your Honor, permission to enter exhibit 19 into evidence.
No objections, Your Honor.
Now, Ms. Cantrell, what, if any, feedback had you received on your initial work?
Well, Skylar Coleman told me that he was very happy with my results, and I also got great Yelp reviews.
And now, Ms. Cantrell, I'd like to talk about two incidents. Now, can you tell us what happened on May 2020?
Yeah, so basically, I was talking to another employee and I was handling a firearm, and someone saw me and they thought that I pointed a gun at them, but the gun was facing around the entire time, and it was unloaded, and my finger was not near the trigger at all.
And secondly, Ms. Cantrell, can you tell us what happened on November 2021?
Yes, so I was going to the shop counter to empty out the bullets of the gun when Skylar Coleman yelled at me to come into his office once I put the gun on it. I'd like to about something.
Clarify for the jury, You were never carelessly handling that gun.
No, I was not.
Now, I'd like to talk about the day of the incident. What did you know prior to Mr. Carver's arrival?
I knew that Carbo would be purchasing a Glock 22. Carbo had never been around firearms before, so I had to be extra safe and tell him all the safety instructions that I usually use to every single customer.
What instructions did you provide him before you entered the ring?
I told them to treat every gun as if it were loaded and never point another gun at someone unless intending to shoot.
And once you entered the range, where did you position?
I told them to stand to the right of me so that they would have appropriate distance from me so that I could handle the gun safely and that they would have the best viewing point of my demonstration.
And after you positioned Mr. Carbo, what instructions did you provide?
I told them that new gun users would often flinch in anticipation of recoil and just to be extremely aware of that.
And Ms. Cantrell, what happened when you fired that Glock 22?
When I fired the Glock 22, Carbo must have moved by between the times of when I was demonstrating how to hold the gun and when I actually fired the gun, because Carbo's arm bumped into mine and that caused the gun to discharge the second time.
Ms. Cantrell, do you believe you took every precaution you could when instructing Mr. Carbo?
Yes, I was extremely careful. I did everything correctly. I followed every single gun range rule, and I expressly warned them of recoil and all the rules that they needed to follow. It's not my fault that Carbo bumped into me and into my space. And although I feel extremely sorry for Carbo, I just know this.
Thank you.
Cross-examination. Ms. Cantrell, before even teaching this firearm safety lesson to Justice Carbo, you had violated 2 rules of the Shooting Star range.
I had allegedly done this, but not. Okay.
Allegedly or not, Skylar Coleman, the owner of Shooting Star, still recorded in your official record that you had broken 2 rules.
Yes, Skylar Coleman is very thorough.
Now, even though you are the firearm safety instructor that teaches these rules, you never had any restrictions placed on you, even though you had 2 violations.
I had no restrictions, but they were written down and recorded, and I got a very good judge.
Now, in regards to your actual experience with firearms, you've never had any professional training in the usage of firearms.
Not professional, but I have been around guns my whole life, especially hunting, and I was on the archery team for target practice.
You've never had any professional training on how to teach others how to use firearms.
Not professionally, but everyone has to start somewhere, right?
So in your own words, to get these 2 firearm certificates, which made you qualified, you only have to sign a few more papers.
Not for the first certificate. I obtained my firearm safety certificate, which required lots of paperwork. To obtain my firearms instructor certificate, that only required a few more.
So beyond lots of paperwork, you never had to have any training to actually make you qualified on how to teach others how to use firearms.
Not any training, but since I was already a sales clerk and I was around people who were using firearms and I use firearms for recreation, I knew what it was.
But you never actually saw any other instructors teaching how to actually shoot a gun, did you?
I saw people around the shooting range.
Never an official lesson?
No, not an official lesson.
You only ever saw people shooting recreationally.
Yes, that is true.
Now, in specific regard to Skylar Coleman's interactions with you, you have a criminal record. And Skylar Coleman performed a background check.
Objection, Your Honor, more prejudicial than probative.
Yes, Your Honor. Given the case of C.E. Patron, character evidence is very relevant to the case when it comes to negligent hiring. Now, we are using the presence of a criminal record to suggest that this was a negligent hiring of Drew Cantrell, and thus the probative value of Drew Cantrell having a criminal record and potentially it's thus being negligent hiring vastly outweighs the prejudicial impact that it may have on the jury.
Objection, that this line of questioning is far more prejudicial than probative, as it's going to assert that Ms. her credibility as a firearm safety instructor, as
Look, it's not only that issue, it's going to be the issue of whether your client should hire the person. That is the prejudicial effect breakdown in program value.
This is still going to inflate the perspective of the juror.
That may well be, but it still doesn't meet the.
You have a criminal record,
Yes, I did.
and Skylar Coleman performed a background check,
Yes, he did.
but never actually inquired as to the criminal record.
No, he didn't. He was more interested in my passion for learning about firearms.
Now, speaking of the actual day of the incident, you never actually inspected block 22 that you hired.
No, I did.
So counsel, if you could screen share exhibit 8, which has been previously entered into evidence. Ms. Cantrell, if you could silently read along with me on the 7th bullet point of the rules of shooting star gun range.
Apologies, Your Honor. May we request that opposing counsel take down their exhibit so that we can screen share ours?
Your Honor, may time to pause as well.
Yes.
Thank you, Your Honor.
Apologies, Your Honor, it's down now.
Okay, yep. Here. Here.
Is everyone able to see? Now, if you could silently read along with me, Ms. Cantrell, on the 7th bullet point. Check your weapon. Always make sure your weapon is functioning correctly, properly clean, and safe to use. Is this correct?
Yes.
Now, in your own words on direct examination, you stated that on that day, you had followed all the rules of Shooting Star Gun Club.
Yes, I did.
But you just admitted that you never actually inspected the brand new Glock 22 that you fired.
Well, it's not brand new. There are blocks in the shop, and I have conducted many.
Ms. Cantrell, that was not my question. My question wasn't that, have you ever inspected Glock 22? My question was, did you ever inspect the Glock 22 brand new that day that you fired?
No, I didn't. But during the demonstration, I was following everything.
But you never actually checked your weapon to make sure it was functioning correctly up until when you fired the first shot in front of Justice Carbo and Nick Allred.
No.
So you did not follow this rule on that day.
No, I didn't.
So you violated the rules 3 times.
One of the rules that said, in regards to my other incident, I didn't violate because.
Ms. Cantrell,
The entire time.
but officially on your workplace record, you had already had 2 violations. So this was yet another violation, making it 3.
It was not a violation.
And as the firearm instructor, you yourself may ensure that failure to abide by the above rules may result in the removal from the facility and denial of future shooting privileges.
What was your question? I'm sorry.
You yourself ensure that these rules are followed and those that do not follow them are ejected from shooting.
I'll also note that it says.
Thank you, Ms. Cantrell. That was not my question.
Okay.
You answered it correctly.
Okay.
So, in specific regard to Skylar Coleman and your professional record, even after having violated 3 of the rules that you yourself teach to brand new gun owners, you were never fired by Skylar Coleman.
No, I wasn't. It's only a possibility. Doesn't mean it's gonna happen.
However, even with the presence of May, you would agree that 3 violations of the rules is quite substantial.
It is, but again, I didn't violate it.
However, on your official record, it does say that you have violated 2 of the rules.
Yes, on my official record.
And then on the actual day of, you did not even follow the very rules, did you?
I followed all the rules except for checking the gun.
But it's still very important to follow all of these rules to ensure the safe usage of firearms.
It is important.
And you claim that there was more violent recoil than anything you've ever experienced with that Glock 22.
Yes, but I knew what to do. I knew I had to let the recoil absorb into my arm, which would have been fine
Thank you,
if
Ms.
Carbo.
Cantrell.
May I finish, please? It would have been fine if Carbo wouldn't have moved so close to me.
So you would have still known about this recoil though, if you had simply inspected the gun for any flaws beforehand.
Yes, but I did expressly warn them of the recoil.
However, you yourself never actually inspected the gun, never figured out that there was violent recoil, as you should have. If followed the
Objection,
rules.
Your Honor, ask an answer.
Make your point.
Yeah, yes, Your Honor. Apologies. So in direct defiance of the actual rules, you never inspected the firearm, which could have let you know that there was more violent recoil on that particular firearm than any other. No further questions, Your Honor. No, Your Honor.
Your Honor, during this pause, would you mind if we ask the time remaining?
Absolutely.
Plaintiff time remaining is 21:39, and I have defense time remaining as 25:56.
I have plaintiff time remaining as 21:39 and the defense time remaining as 26. So 4 seconds.
Six.
Your Honor, that calls Avery Real on this. May I proceed, Your Honor? Please introduce yourself to the court.
Hello, my name is Avery Nguyen.
Could you tell this jury a bit about yourself, Mr. Nguyen?
Of course. Well, I moved to Imperial after receiving my bachelor's degree from Georgia Tech, and I currently work in business. But I do have a few avid hobbies outside my day job.
And what are some of these avid hobbies?
Well, it's safe to say that I'm a gun enthusiast. Ever since I first held a gun when I was just 7 years old, it's become an everyday part of my life. I both collect and actively use these guns, and if I do say so myself, it's become much more than just a hobby.
Can you please explain your full experience regarding firearms?
I'm somewhat of a gun expert, actually. I've been using my entire life, as well as using a variety of guns in the process, all bought from shooting stuff.
And are there any other areas that you retain knowledge in?
I am extremely well versed in firearm safety and know the rules like the back of my hand.
I'd next like to talk about your involvement in today's case. How did you initially get involved?
As you can tell, I have been retained by the defense to testify here today on behalf of Shooting Star LLC. I was in the range on the day of the accident and can also attest to my observations of Shooting Star's protocols on a day-to-day basis.
On this day-to-day basis, what was your attendance at Shooting Star like?
Well, I go to Shooting Star multiple times a week, sometimes to work on my customization, and sometimes just to visit the range. My frequent attendance allows me to personally know the employees, and I even eventually got my own shooting stall, nicknamed Avery's Corner.
And over all this time, How have you perceived Shooting Star?
My perspective on Shooting Star's practice that I saw on a day-to-day basis boils down to three main points: organized, observant, and operative.
Well, let's break those down one by one for this jury, starting with organized. What did you observe of Shooting Star's organization?
Every employee at Shooting Star held organization to a very high standard for themselves. They enforced constant background checks, offered free safety training courses with every purchase of a firearm, and overall strictly followed company policy.
Well, let's now talk about our second point, observant. How did employees observe their customers?
When I saw, every employee at Shooting Star observed their customers to the highest regard. They even had safety rangers roaming the range to ensure everyone was behaving properly. They pretty much had eyes on every customer at all times. They even denied my offer to help the newcomers.
Why did they deny your help?
Well, even though I'm incredibly experienced, they put their responsibilities as employees above anything else. They wanted the employees to answer the customer's questions.
Well, that leads us to our third and final point, operative. How was, from what you saw, Drew Cantrell operating the training sessions on the day in question?
Where I was standing, he was informing Carbo and the other trainees of everything I already knew on firearms. You know, the basics. Then after his information session was done, he lined them up to properly demonstrate how to safely shoot a firearm.
And would you recognize where they were lined up in the stall if I showed it to you today?
Yes, of course.
Your Honor, let the record reflect for counsel to please screen share what has been previously entered as Exhibit 2G. Can you see that, Mr. Nguyen, yet?
Not you.
How about now?
Your Honor, apologies, we're having a bit of technical difficulty at this time. Are we able to pause just a moment?
Let's stop.
Your Honor, in addition, our counsel would be more than happy to screen share Exhibit 2G. You can have it pulled up.
That would be very, very helpful.
Yeah, please, let's start.
Thank you.
Is this a fair and accurate copy?
Well, of course.
And could you just briefly describe this exhibit?
Yes, this is where everyone was standing on the day in question.
Your Honor, permission to reference the document that has been previously entered into evidence and is recognized that it's entered. And could you please address how everyone was standing in the stall that day?
Yes, of course. On this day, Mr. Cantrell was standing the closest to me, followed by Mr. Carbo, and then Mr. L.
And does this space accurately represent what you saw?
Yes, it does. And as you can see, Carbo was standing far too close to Cantrell, far closer than the other trainer. The last thing you want to do when someone is handling a firearm is crowd them away Carbo. The next thing I knew, I heard 2 shots fired in rapid succession.
And what did you observe when you heard 2 shots?
After the first shot was fired, I saw Carbo jump and bump into Cantrell, who was still holding the firearm. Shortly after the second shot was fired, around the same time, both Carbo and the gun fell to the ground.
And with all this in mind, Mr. Nguyen, what are your final remarks on Shooting Star Gun Club?
I mean, as far as I'm concerned, Shooting Star acted exactly as what we expected. They were organized, observant, and operative in running their business, and especially on the day in question. They followed every protocol and made safety a top concern.
Thank you, Mr. Nguyen. No further questions, Your Honor.
Yes, Your Honor. Mr. Nguyen, I'd like to talk about something that you mentioned on direct examination. You talked about how Shooting Star gives every customer a complimentary safety training course, correct?
That is true.
But isn't it true that, in your own words, the only time that you never were asked about this complimentary safety training course was when Skylar Coleman was selling you a product?
Yes, Ms. Coleman is not an employee, she is the owner, and she is very well aware of my experience, and knew I did not need it.
But Ms. Coleman would sell firearms in the shop, correct?
That is true, sometimes to me.
Now, you were in Shooting Star in May of 2021 when one of their employees violated a basic safety rule,
Yes,
and this employee was Drew Cantrell.
that is true.
You saw Miss Cantrell point a gun at another person.
From what I believe, I was leaving the range that day from a very long day working on my customizations, and that is what I thought of myself, but yet again, it was out of context.
But Mr. Nguyen, you did see Miss Cantrell point this gun.
Yet again, it's from what I believe. Context is key, and I did not have context.
You were also at Shooting Star on the day of the shooting on May 28th, right?
That's true.
At the time, you were in your own stall 3.
That is not true. I was on the table adjacent to stall 3, working on my customization.
However, you were just behind stall 3.
That's true.
And the shooting occurred in stall 11.
That is also true.
So there was about 30 feet between you and where the shooting happened.
Yeah, roundabout.
You didn't have the best view of what happened.
Yet again, I was working on my customizations at the head of the table closest to stall 3, so I was facing that direction, and all the commotion definitely alerted my attention.
But you're only pretty sure that you saw nothing out of the ordinary when Miss Cantrell first aimed the gun.
I mean, pretty sure, but I'm very, very certain. Can't be 100%, but very sure.
But Mr. Nguyen, in your sworn affidavit, you said that you were only pretty sure.
Yes, as I said. I can't be 100%, but I am fairly certain.
And you only think that you saw Mr. Carbo jump after the first shot?
I was using my peripheral vision, which as an expert in hunting, I am accustomed to using. I'm used to seeing things out of the periphery and acting upon it, and that is exactly what I did in the situation.
But again, you only think that you saw him jump.
For the third time. I cannot be certain if I am.
So you weren't watching very closely at all.
I was working on my customizations, and yet again, the commotion did alert.
So you can't be certain about what actually happens during the shooting.
I have a good enough idea to testify today.
But Mr. Nguyen, you cannot be certain.
I cannot be certain, but yet again, I can be fairly sure.
No further questions, Your Honor.
No redirect, Your Honor.
Your Honor, at this time, the defendant calls Dr. Captain Jacqueline Saab to stand. Good evening, can you please introduce yourself for the jury?
Good evening, my name is Jack Staub, but you can call me Captain Staub.
Captain Staub, can you please tell us what you do for a living?
Yes. I currently own my own firearms examiners firm called Staub Examiners LLC, where my team and I work to examine firearms as well as different safety regulations, and I occasionally testify in different firearm-related cases such as
Captain, taking a step back, can you talk a little bit about your education prior to opening your firm?
Yes, sir. I received my bachelor's in physics with a minor in photonics from the from the Military Academy at West Point in 2002, where I graduated from my.
And following your experience in West Point, do you have any military experience?
Yes, I was deployed in Iraq for 7 years, where I served as an artillery officer. I also worked hard enough that I earned from the National Rifles Association and the United States military the honor of being called distinguished shooting expert.
Yes. Captain, with that understanding, can you tell us how exactly you got involved in today's case?
Yes, sir. I was retained with the defense to answer 2 questions. One, if Skylar Coleman recklessly entrusted Drew Cantrell with a firearm, and 2, to determine if Drew Cantrell followed the proper safety regulations on the day in question.
On the rendition and upon your review of the case, have you rendered an opinion for us today?
Yes, sir.
And what materials did you rely upon in that rendition?
I relied upon the deposition of Skylar Coleman as well as the deposition of Justice Carbo. I also relied on exhibits 1 through 22 as well as my decades of experience.
Do you hold all opinions you're about to make today in this courtroom to a reasonable degree of professional certainty?
Yes, sir.
And all those materials are typical, I trust, to your field?
Yes, sir.
Your Honor, at this time, the counsel for the defendant moves to offer Captain Jacqueline Staub as an expert in the fields of physics, photonics, and firearm mechanics.
No objections, Your Honor.
Captain, to begin, do you feel it's important that anyone evaluating the accidental discharge that day understands physics and photonics?
Yes, sir.
And with that understanding, can you please state your opinion involving physics and photonics?
So after reviewing the case holistically, what I discovered is that 1, Mr. Cantrell did properly follow the safety regulations, and 2, I determined that Mrs. Skylar Coleman did properly entrust Drew Cantrell with the weapon as he was fit to use it.
Well, I want to break down both pieces of that opinion you just mentioned, Captain, beginning with the first, that Mr. Cantrell was fit to be entrusted with the weapon.
Yes, sir.
So throughout today's trial, it's been the plaintiff's contention that Miss Cantrell, had some previous incidents in her past. Are you aware of such incidents?
Yes, I am aware of these incidents. I reviewed them in my holistic review.
Can you describe them for this jury?
Yes, sir. What I discovered was that one of these incidents that counsel is referring to is that Miss Cantrell did take a loaded weapon from the line of fire to unload it in the gun shop, but the shop was vacant. They were partially talked to by Miss Coleman herself, where she did then proceed to write them up. The second thing I noted was that Miss Cantrell was inspecting an unloaded firearm and accidentally put it in the direction of a fellow coworker, causing a little bit of miscommunication, which was eventually ironed out.
So with that understanding, why shouldn't these incidents render her unfit?
It's in my opinion that 2 isolated incidents don't render a person unfit. These were 2 isolated incidents over 2 decades worth of experience. If anything, it's shown that Miss Cantrell has learned from her mistakes and that she's human just like the rest of us.
So I want to be clear, Captain. Do you feel Miss Cantrell is fit?
Yes, I do.
And was there anything else that led you to have knowledge of her fitness?
Yes. I also found it particularly interesting how quickly she was able to obtain her firearms certificate. Now, this certificate is similar to a driver's license. There's really a bunch of red tape to cut through in order to get this. But I find it particularly interesting that the government moved so quickly and swiftly to present her with her firearm safety certificate. So if the government has shown that they have trusted her, then why should we afford her to say?
Now, with that understanding, Captain, I want to move on to the second piece of your opinion. The fact that Ms. Cantrell complied fully with firearm safety standards that day. Now, you're also aware it's been the plaintiff's contention that his handheld flinched before firing that first shot. Are you?
That's one version that I've read.
And did you find this to be true?
I did not. After relying upon the testimony of Avery Nguyen, what I found was that Mr. Cantrell did not flinch. I relied upon this deposition, this testimony in particular, purely because they are experienced and have had decades of time using weapons.
So if a flinch didn't cause the accidental second discharge, what could have happened?
What I found to be the cause of today's incident was a defective Glock 22.
And did you examine that Glock 22 that was used that day?
Yes, sir.
And so, can you tell us, or would you recognize a potential standard demonstration of a typical Glock 22?
Yes, sir.
Would it help guide your explanation of how a typical Glock functions for this jury?
Yes, sir.
Your Honor, at this time, I wish to screen share Exhibit 25 for identification purposes. Captain, can you please just let me know when you're able to see that on screen? Wonderful. Can you explain what this is for this jury?
This is a typical Glock 22. As you can see, you can see the barrel, you can see the chamber where the bullet lies. You can see the cartridge, which cartridge otherwise has the magazine that holds all future bullets that can be loaded. As you can see, and you can also see the trigger. So you see that when the trigger is pulled, the bullet is fired, then automatically a new bullet is loaded to the chamber so that it's ready for the next time the trigger is pulled.
So the only thing separating one shot from another is the singular press of a trigger?
Yes, sir. When the trigger is pulled, the bullet is automatically reloaded, making this a semi-automatic.
So with the understanding of how a typical Glock 22 functions, can you tell us how this one in particular on the day in question was defective? Would it help if you were able to see the gun itself for the jury?
Yes, sir, it would.
Your Honor, at this time, I ask you to approach the witness because of what has been previously marked and entered pre-trial as Exhibit 1, the Glock 22 used on the day in question. Captain, do you recognize it?
Yes, I do.
Can you tell us, jury, what that is?
This is a defective Glock 22 that we used in the game question.
And can you tell us in what way it was defective? Describe it to the jury.
Well, I found there to be there were two primary things that were defective with this gun. One being the abnormally harsh recoil that happens when this particular gun is fired, and two, the atypically sensitive trigger. Now, with this gun in particular, when you are asserting control over a weapon, typically you're able to have a slight touch on the trigger. That way you're ready and in the proper position when you want to fire the weapon again. But with this gun in particular, even the slightest touch of this trigger can cause it to fire.
So would someone, let's just pretend an expert without experience in physics or photonics, be able to identify that as a defect in the weapon?
It's possible.
Would it be likely that someone without that experience would recognize it as a defect in the weapon?
No.
Objection, lack of personal knowledge.
Maybe heard, Your Honor? I'm asking Captain Stout here to make an opinion as to whether or not he feels another expert without experience in the field he has and would be able to recognize such defect with the weapon. I feel as though it's perfectly within his field of expertise as an expert in physics, photonics, and firearm mechanics to make an informed decision or make an informed opinion as to whether or not someone without his experience would be able to recognize the various things that lie within his experience.
Yes, Your Honor. While opposing counsel did mention other experts in the field, which this witness might have knowledge of, the actual question at hand was about a quote, non-expert. That could be any single person. We have no idea who this person is. And somehow opposing counsel is asking this witness to determine their mental state at the time of looking at a gun.
Maybe heard, Your Honor?
I think in context, we all know.
Captain, could I re-ask you that question? Would someone without specialized physical and photonical knowledge be able to identify what you did with that weapon?
If we're talking about particularly the experience with physics and photonics, then no.
So with that understanding, would it help you to demonstrate how exactly the defects with that weapon contributed to the accidental discharge that day?
So,
Your Honor, at this time, I ask the witness to step down from the stand for a demonstration.
the day in question, what I found was that after a holistic review of the case, Mr. Cantrell was aiming the weapon at the target. Now, when the gun was fired, the recoil caused her arm to launch back. Now, as a trained expert in weapons, she was attempting to assert control over the weapon. But again, after reviewing the case and expert witness testimony, they stated that Mr. Carville was closer to Ms. Cantrell than she anticipated. So when she was attempting to assert control over the gun, he bumped into her arm. And as I said about the atypically sensitive trigger, when her finger lightly touched the trigger, it resulted in the gun firing into Ms. Carville's leg.
With the combination of these defects and Mr. Carbo's change in position, was there anything Ms. Cantrell could have done to stop this?
No, she did everything in her power as any trained person would.
So what's your final opinion on today's case?
My final opinion is that this was a matter of two incidents being combined, resulting in a catastrophic incident. What I found was that it was a combination of an atypically sensitive trigger and a overly harsh recoil, combined with Mr. Carville being in the wrong positioning and not following Ms. Cantrell's directions. As a result of those two things being combined, what typically would be Ms. Cantrell attempting to assert control over the weapon and avoiding an incident resulted in Mr. Carville being in the wrong positioning and being fired into.
Do you have any final thoughts on today's case for the jury?
Yes. While this was a tragic accident that happened, it was exactly that, an accident. Ms. Cantrell did everything in her power to avoid this situation, but there was nothing else she can do with this as a result of this effective weapon. Now, I feel awful for the position that Mr. Carville was in, and I am keeping.
Objection, there it is.
That would okay.
There are the questions, got it right?
Good evening, Captain. To begin with, you would say that you thoroughly reviewed all of the materials provided, wouldn't you?
Yes, sir.
And after thoroughly reviewing all of those materials, you included all of the relevant possible causes of Mr. Carbo's injury in your report. Is that also correct?
Yes, sir.
Now, before we talk about the actual contents of that report, I would like to focus on a couple things that occurred on direct examination. Now, essentially, I heard 3 different statements as to the cause of Justice Carbo's injury. And in fact, I wrote them down right here. Now, first, you stated that there was an atypically sensitive trigger. Is that correct?
I said that.
Mr. Staub, I'd like to talk about that for a moment. Is it your testimony that this trigger was different from any other Glock 22, any other gun of this model?
I said that this gun in particular had an overly sensitive trigger, yes.
So again, it's your testimony that this gun had a different trigger sensitivity than any other gun of this model?
If you're asking me if a Glock 22 has an overly sensitive trigger, then yes.
I'd like to talk about that a bit more. You just said that a Glock 22 has an overly sensitive trigger.
What I said was, this Glock 22 has an overly sensitive trigger.
I think you're going back and forth. Could you please answer this next question with a yes or a no? Is it your position that this Glock 22 had a lighter trigger than other guns of this model? Yes or no?
What I said was, this Glock 22 had an overly sensitive trigger, yes.
Mr. Staub, that was not my question. I asked if this Glock 22 had a different trigger than any other model. Yes or no?
No.
So, Mr. Staub, you would agree with me that the light trigger, which you call defective, is actually a well-known characteristic of the Glock 22 gun.
Can you please state your question?
Captain, you would agree with me that the light trigger that you called defective is actually a well-known characteristic of the Glock 22.
You're asking me if Glock 22 is typically,
Mr. Saab, a yes or no will suffice.
if you want to answer the question.
Go ahead.
If you're asking me if a Glock 22 typically has a sensitive trigger, then yes. But as you've read in my review, I said that this Glock 22 has an overly sensitive trigger, yes.
Mr. Saab, again, you have not answered my question. I was asking if the Glock 22 light trigger is a well-known aspect of the gun.
I said, as I stated, counsel, the Glock 22s do typically have a light trigger.
Objection, Your Honor, the witness is being non-responsive and not answering my question.
He's entitled to a yes or no. You can briefly explain. Yes, a question that calls for a yes or no. Needs to be in your answer with a yes or no. My apologies.
Yes, these guns do typically have a light trigger.
Captain Saab, that was not my question. I asked, is the light trigger a well-known aspect of the Glock 22? Yes or no?
As I stated, yes, these guns do typically have a light trigger.
Objection, Your Honor, the witness is again being non-responsive and not answering whether or not this is a known fact.
Yes. I think, please do that.
Yes, Your Honor. Now, moving on from the known aspect of the light trigger, I'd like to talk about the second point that you made. I believe you used the words abnormally harsh recoil. Is that correct? Mr. Saab, if I'm correct, you read the affidavit of Drew Cantrell, right?
Yes, sir.
And in that affidavit, you're aware that he said that there was an extreme amount of recoil,
Yes, sir.
perhaps unmanageable.
Yes, sir. One person can see it that way.
However, Captain Saab, after examining the gun, which you did, right?
Yes, sir.
You examined the exact gun used?
Yes, sir. I examined this exact gun that was used.
Captain Saab, after examining this exact gun, you found nothing wrong with it that would indicate that the recoil would be any different than expected. Isn't that right?
That's not what I said to you today. And part of my holistic review is the reviewing this weapon, which includes me trying out the weapon. That's part of checking the weapon. So when I checked it, I did find that this had a harsh recoil. And
Mr. Saab, is it your testimony that this gun, after you inspected it, you fired it and there was a harsh recoil? Is that your testimony?
if you're asking if this gun had a harsh recoil,
Mr. Saab, a yes or no will suffice.
I'm attempting to clarify your question. I just want to clarify before I can answer.
Yes.
Are you asking me if this gun had a harsh recoil?
Mr. Saab, I'm asking again, if after reviewing this gun, after examining it, you found that it had a harsh recoil.
Yes, I found that it had a harsh recoil.
Mr. Saab, you wrote an affidavit for today's case, did you not?
I did not write affidavit.
Apologies, you prepared a report,
That I did.
and in that report, you were aware that you had to tell the truth and nothing but the truth.
Yes, I was aware of that.
You're aware that you could change that report at any point up until today's proceedings.
Yes, sir.
Your Honor, let the record reflect, I am providing the witness with a copy of their affidavit for identification.
Your Honor, I'd ask the opposing counsel to first see the line numbers of the referencing as well.
Yes, line 144. Again, let the record reflect, I'm providing the witness a copy of the affidavit marked Jackie Saab. Could you please ensure that this is in fact your affidavit?
This is my affidavit.
Or the report?
It's the report.
And is that your signature on the last page?
Seems to be.
Now, I'd like to direct your attention to line 144. I'd like you to read along silently as I read this aloud. I examined the exact gun used by Cantrell, the Glock 22. This handgun model is known to have a light trigger, meaning the force required to depress the trigger is less than that of comparable handguns. Did I read that correctly?
Yes.
Mr. Saab, what you did not say is that I examined the gun and I found that the recoil was extreme, did you?
No, but if you thoroughly read my report, you would see that in my report, I did mention that there was a harsh recoil as well.
Mr. Staub, could you please point where in your report you say that there was a harsh recoil?
Not at this moment, because I think that would take time for me to go through and find the exact line.
Mr. Staub, you did write this report. I would like you to show me where it says there was a harsh recoil.
Your Honor, do not have to go through the entire evidence.
Stop the clock. Take the time to read it.
Counsel, would someone please bring me my glasses from the floor over there?
Just clarify, Your Honor, this is off the board.
Where is that? If you refer to my analysis section, you see that in line. You see that in line 135 moving on, I state, if Cantrell flinched prior to the first shot, the grip and point direction of the gun would have changed. This means that the recoil from the first shot would have been unmanageable. I did mention a recoil in this affidavit, in this report.
Thank you. Now, Captain Staub, again, you started off reading that sentence with if Cantrell flinched, right?
I did.
So exactly, if Cantrell flinched, that would perfectly explain why Cantrell experienced more recoil, isn't that right?
Well, if we're referring to this, if we're referring to my report, if
Objection, Your Honor, the witness is being non-responsive.
you received the question.
Of course. If after, as you just read, after someone flinches, the recoil would become unmanageable. If that was the case, that would explain exactly why Drew Cantrell experienced the recoil that you read about, right?
That's one version, but if we would continue, you would see where I say I found it highly unlikely that.
Mr. Staub, I'm not asking about whether or not you found the possibility unlikely. I was only asking if what you read, you looked through the whole affidavit and you found that line. I was just asking if that line would explain why Drew Cantrell had more experience, more recoil.
And as I said that's one version.
Exactly, it would explain.
I said that's one version.
Now, I'd like to move on to the final point you mentioned. I believe you said that the close proximity was the final step of your process, right?
Yes, sir.
Mr. Staub, again, nowhere in your affidavit you mention a single word about the proximity of Justice Carbo to Drew Cantrell. Isn't that right?
Again, I wrote a report, and in this report, my testimony here today is a holistic review.
Objection is non-responsive.
Again, can you restate your question?
Captain Staub, nowhere in your report you mentioned anything about Justice Carbo's location. Yes or no?
Not directly in the report.
Not directly in your report. Jackie,
Can I finish my statement?
I believe you sufficiently answered my question. Again, just to reiterate, you testified earlier that that report included the totality of your opinions on this case. Did you not?
My report is a part of my findings, yes.
Your Honor, at this time I have no further questions.
Yes, Your Honor.
Captain, On cross-examination, opposing counsel had a lot of questions about what you said and what you didn't say in your report. Would you recognize that report again if I presented you a copy of it?
Yes, sir.
Your Honor, permission to approach witness? Can you please read aloud the conclusion you reached from line 144 down to 148 for the jury aloud?
I examined the exact gun used by Cantor on Glock 22. This handgun model is known to have a light trigger, meaning the force required to depress the trigger is less than that of another comparable handgun. Thus, the gun's recoil from the first shot may have caused Cantor to repress the trigger through no fault of their own. If the handgun had a strong trigger, Cantrell's finger resting on the trigger would not have caused it to fire.
And that would not have caused Mr. Cantrell to flinch, correct?
Exactly.
And that's exactly what your conclusion was.
Yes, sir.
No further questions, Your Honor.
Briefly recross, Your Honor. Mr. Staub, in that line you just read, it did not say a strong recoil, did it? It just said recoil.
It does say recoil, yes.
No further questions, Your Honor.
Your Honor, permission to retrieve the affidavit. Or excuse me, the report.
Your Honor, may I also retrieve?
Sure. And I think that was, address, yes.
Mr. Honor, that's correct.
Timekeepers, how would you handle this in the 5-minute recess when
Your Honor, all loss is going to be at 6:53 p.m. So we have 26 minutes.
we went off the clock for.
I currently have 8 minutes and 55 seconds for plaintiff and 8 minutes and 32 seconds for defense.
All right, let's go ahead and take 5.
What do you have left?
Closings.
Closings?
Yeah.
Okay, awesome. Did you get the message about the iPhone?
Oh yeah, we returned it to the Buckingham room. Okay.
Awesome. And then we'll just pizza.
Okay. No. Oh, yeah, I just come here from school. I'm from the Philippines.
Oh.
Yeah. I have not gone to the weather 2.5 years.
You're not gotten used to it?
Yeah, I mean, today was better, but like, it's like, yeah, like, I mean, like snowfall, like the first time you see it is fun. And then when you're just like walking in snow, you're like, I hate this.
Like you're standing outside and just like,
Your Honor, I request that my remaining time be reserved for rebuttal.
You may proceed to the closing.
Yes, Your Honor. Your Honor, opposing counsel and members of the jury. Shooting Star saw the signs. They ran the risk. The defendant knew that Drew Cantrell was unfit. Yet, on May 28th, Shooting Star was willing to ignore the danger and send Justice Carbo out on the shooting range. Drew Cantrell should have never been a firearms safety instructor. And now, Mr. Carbo is paying the price for that reckless decision. Today, we have proven by a preponderance of the evidence that the defendant, Shooting Star Gun Club, was negligent in hiring Drew Cantrell as an instructor. As my co-counsel, Ms. Newbor, explained earlier, this means that if the evidence we presented today tips the scale even slightly in favor of the plaintiff, then you must hold the defendant accountable for Mr. Carbo's injuries. The greater weight of the evidence has clearly established that Drew Cantrell was incompetent in her role as a firearms safety instructor, that the defendant knew or should have known about this incompetence, and that it created a risk to others, and that the defendant's negligence in hiring Ms. Cantrell was directly responsible for Mr. Carbo's injuries. The signs of Drew Cantrell's incompetence were clear. Sign number 1. In May of 2021, Ms. Cantrell violated one of the most fundamental rules of gun safety. Never point a gun at something unless you intend to shoot it. Yet, as you heard from Ross Hernandez and Avery Nguyen, in a heated argument with another employee, Ms. Cantrell raised her firearm and pointed it directly at her coworker. Ms. Cantrell should have been fired for this infraction. Sign number 2. Just 3 months later, the defendant decided to promote its employee, the one who had violated basic safety rules, to be its firearms safety instructor. But members of the jury, what evidence did you hear today to suggest that Ms. Cantrell was fit for this position? A few pieces of paper, and that's it. Otherwise, Ms. Cantrell had no qualifications. You even heard her on the stands today admit that she had no formal training and no instructional experience. What she did have was a criminal record that the defendant either knew about and ignored, or that the defendant should have known about if they had actually run a background check. Sign number 3. In November of 2021, Ms. Cantrell violated yet another basic safety rule. You heard that she brought a loaded gun into the shop. And when the defendant found out, what was the response? Just like the last time, the defendant gave Ms. Cantrell a written and verbal warning and sent her right back out on the range to teach others how to be safe. This leads us to May 28, 2022, when the defendant ran the risk. Justice Carbo, a gun novice, goes to Shooting Star and takes a safety training course, reasonably anticipating an expert instructor. So when Ms. Cantrell tells Mr. Carbo to stand right next to her during the shooting demonstration, he listened. After all, Ms. Cantrell was supposed to be the safest person on the range. Members of the jury, the Shooting Star saw the signs that they ran the risk. The defendant knew that Drew Cantrell pointed a gun at another employee. The defendant knew that Ms. Cantrell had no qualifications and no experience. The defendant knew that Ms. Cantrell brought a loaded gun into the shop. But in spite of seeing these signs, Shooting Star permitted Ms. Cantrell to teach hundreds of safety courses for 6 months, until eventually On May 28th, risk became reality. And now Justice Carbo is paying the price. We ask that you find the defendant Shooting Star Gun Club liable.
Can I proceed? It was an unfortunate accident, but it was just that, an accident. May it please the court, opposing counsel, your honor, members of the jury. Today plaintiff has come before you trying to say that Shooting Star Gun Club is at fault for the accident that befell Justice Carbo. But what they won't admit, it was just that, an accident. They are trying to appoint someone to blame when this accident is blameless. It's as simple as that. But through our evidence today, we have demonstrated their notion as false. Through our witnesses, as well as their own witnesses, you heard how Justice Carbo wants to take every penny from Shooting Star. You heard how Ross Hernandez does not have an actual contention against whom she is testifying against. And you heard how Dr. Judd actually agreed with our counsel that Ms. Coleman acted the way she should have in reprimanding Cantrell. We, the defense, bear no burden in today's case. That rests on the shoulders of the plaintiff. They must prove, by preponderance of the evidence, that Shooting Star Gun Club was negligent in the hiring, supervision, or retention of Drew Cantrell. And I'd like you to think of preponderance of the evidence as two scales, one for each respective side of the party here today. Throughout today's trial, evidence has been placed on each side of the scale, but has continuously tipped in favor of the defense, which is why at the end of today's trial, we will ask you to find Shooting Star LLC not liable. And we have demonstrated that non-liability here today for three reasons: diligence, distance, and defective. Let's break those down one by one, starting with diligence and how Drew Cantrell was as diligent as she possibly could have been. Now, Drew Cantrell took the stand before you all today and told you how she informed Justice Carbo on the day in question of all the safety precautions and how she followed every protocol during that training course. But what Drew Cantrell also informed you of was Justice Carbo's lack of experience with firearms. So when she took that gun and aimed it and discharged it, Justice Carbo flinched, causing him to evidently strike Miss Cantrell's arm, causing the firearm to shoot another time. The plaintiff has come before you trying to appoint someone to blame, but maybe they should examine their own party's faults on the day in question. Second, distance, and how Justice Carbo was standing dangerously close to Miss Cantrell during the training course. We secondly called Avery Nguyen, who has expert-like experience in firearms and firearm safety. Now, Avery Nguyen has attended Shooting Star almost every day, and through all this time, he has never found a fault with Shooting Star's practices of safety. And Avery Nguyen was also in the range on the day in question, working on his customizations. And when he looked over to that stall, he saw Justice Carbo crowding Miss Cantrell. And that makes me pose a question here today. What is the logic of relying on someone's testimony who has a bias against guns and who also has no gun experience, rather than relying on someone who has attended Shooting Star almost every day and has the utmost experience in firearms? And finally, that leads us to our last and third point, defective, and how that Glock 22 was undeniably defective. We lastly heard from Jackie Staub in today's case, who is an expert in firearms and firearm safety, as well as physics and photonics. Now, they explained the mechanics of this Glock 22, how it had an oversensitive trigger, as well as a harsh recoil, which means this accident could have befell anyone, even someone with years of experience handling and discharging firearms. Accidents happen, members of the jury, even when precautions are in place. And this case is a perfect demonstration of this fact. Members of the jury, today defense came before you to demonstrate this non-liability for 3 points: diligence, distance, and defective. I remind you of 2 scales symbolizing preponderance of the evidence and how they have tipped in favor of the defense today. Now, it is your job not to choose to appoint someone to blame to a blameless accident. Find Shooting Star Gun Club not liable. Thank you.
Yes, Your Honor. Opposing counsel has claimed that what happened on May 28th was a tragic accident. And I would agree, it was an accident, but it was an accident that could have been prevented if Drew Cantrell was actually competent. I'd like to address these 3 points that the defense has brought up today: diligence, distance, and defective. The defense wants you to believe that Drew Cantrell exercised due diligence on May 28th. However, you heard Ms. Cantrell admit today that she never even inspected the gun that she was using to teach Mr. Carbo. Now, for distance, the defense wants you to believe that Mr. Carbo was standing too close. However, remember that it was Ms. Cantrell who told Mr. Carbo where to stand. In fact, the defense has provided no evidence of anyone, including Ms. Cantrell, ever telling Mr. Carbo to move. And members of the jury, since Mr. Carbo is a gun novice, he wouldn't have known that he was supposed to move unless the experts on the shooting range, Ms. Cantrell, would have told him. And finally, for defect, the defense has brought their experts, Jackie Staub, to claim that the Glock 22 used on May 28th had an uncontrollable recoil. However, what they failed to mention is that Captain Staub admitted today that this recoil would have been caused if Ms. Cantrell flinched, which the defense claims is not what actually happened. So members of the jury, I ask you, opposing counsel has said that the scales have tipped in favor of the defense, but have they actually? Because members of the jury, the defendant saw the signs. Drew Cantrell was incompetent. They ran the risk, and it caused Mr. Carbo to get shot. Find the defendant liable.
This. Let's give it a good round of applause. Come back, at 54.